Hi, welcome to SGT University. I am Professor 𝗘-𝗟𝗲𝗿 from the Faculty of Mass Communication and Media Technology. Today, we will be learning about the topic of appointment of judges. As we discussed in our previous topic, in India, the structure of judiciary is pyramidal. We have the Supreme Court at the top of pyramid. We have 25 high courts in the middle and district and subordinate courts across the districts. For appointment of judges, we will discuss this separately for all the courts. So, in today's lecture, we will be dealing with the appointment of judges. First of all, we will go into the appointment of Chief Justice of India and judges of the Supreme Court. Chief Justice of India and judges of Supreme Court are appointed by the President under Clause 2, Article 124 of the Constitution of India. The eligibility of the judges: a person should have been a judge of one or more high courts consistently for a period of 5 years or more, or a person should have an experience of 10 years standing as an advocate in high court, or a person who is distinguished or considered eminent jurist in the opinion of the President. First of all, Chief Justice of India. Appointment to the office of Chief Justice of India should be of senior most judge of Supreme Court considered fit to hold the office. The Union Minister of Law, Justice and Company Affairs would, at an appropriate time, seek the recommendation of the outgoing Chief Justice of India for the appointment of next Chief Justice of India. After the receipt of recommendation of the Chief Justice of India, the Union Minister of Law, Justice and Company Affairs will put up the recommendation to the Prime Minister, who will advise the President in the matter of appointment. Now, judges of the Supreme Court. Whenever a vacancy is expected to arise in the office of Judge of Supreme Court, the Chief Justice of India will initiate proposal and forward his recommendations to the Union Minister of Law, Justice and Company Affairs to fill up that vacancy. The opinion of Chief Justice of India for appointment of a Judge of Supreme Court should be formed in consultation with a collegium of 4 senior most puisne judges of the Supreme Court. After receipt of final recommendations of the Chief Justice of India, the Union Minister of Law, Justice and Company Affairs will put up the recommendations to the Prime Minister, who will advise the President in matter of appointment. As soon as the warrant of appointment is signed by the President, the Secretary to the Government of India in the Department of Justice will announce the appointment and issue necessary notifications in the Gazette of India. Now, Chief Justice and judges of the High Courts. The High Court judges are appointed by the President on the advice of Chief Justice of India, because Chief Justice of India is also head of judiciary in India and also of the Supreme Court of India. The Governor of the state at that time and also the Chief Justice of that designated court will also be consulted. Now, eligibility of the Chief Justice and judges of High Court. A person to be eligible to be a High Court judge must be an Indian citizen. He or she must have at least 10 years experience as a judge in any court in India, or he or she be an advocate with an experience of at least 10 years of standing in a High Court. Even the jurist considered eminent by the President of India can be a High Court judge. Now, let us come to the topic of removal of judges of Supreme Court and High Court. It should be very clear to you that there is almost no scope of political interference in the appointment of judges, because we have already seen that the appointments are done on the recommendation of collegium of 4 senior most puisne judges. Furthermore, once a person is appointed as a judge of Supreme Court or a High Court, it is almost impossible to remove that person from that post. However, a judge can be removed if an impeachment motion is passed separately by 2/3 members of the two houses of parliament, that is Lok Sabha and Rajya Sabha. This has never been done in India. So we can say that it is almost impossible to remove a judge of the High Court or the Supreme Court. Now let us come to the controversy over the appointment of the system which is prevalent in India for the appointment of judges of Supreme Court and High Court. For the past some years, controversies are being raised over the manner in which judges are being appointed in the Supreme Court and High Court, and it is being said that judges appoint judges in India. Now we'll deal with this national judicial appointment system which Modi government, when it came to power in 2014, the government brought an act which was called National Judicial Appointment System Act 2014. This was enacted by the Narendra Modi government to regulate the procedure to be followed for recommending the names of appointment of Chief Justice of India and other judges of the Supreme Court, and Chief Justice and other judges of the High Courts and also for their transfers. However, this was struck down by the Supreme Court. On October 16, 2015, a 5-judge Constitution bench of Supreme Court struck down the Constitution's 99 amendment that has paved the way for the creation of National Judicial Appointment Commission, replacing the existing collegium system for appointing judges to the High Courts and the Supreme Court. More controversies began regarding this. Some parliamentarians also demanded a change in the manner in which judges are appointed, and they have said that the collegium system needs to be revisited. It was said that the present system leads to nepotism in the judiciary. Law Minister Kiren Rijiju also told Parliament that there were calls from several quarters to bring transparency in the judges' appointment process. Recently, President COVID also favored all India judicial services. In November 2021, referring to the issue of judicial appointments, the President Ram Nath Kovind, while speaking in an event where the Chief Justice of India was also present, he favored creating all India judicial services for the recruitment and appointment of judges at all levels of judiciary, saying that the idea is in voyage for the last 5 decades but has never been tested. But the Chief Justice of India countered the claims of judges appointing judges. Chief Justice of India N.V. Ramanna countered most of these claims while delivering a lecture in Vijayawada. He said that it was a myth that judges appoint themselves, and clarified that several other authorities, including the Law Ministry and the intelligence bureaus, were involved in the process of appointment of judges. He said that nowadays it is fashionable to reiterate phrases such as judges are themselves appointing judges, and he stated that such narratives suit certain sections. Now we will come to the appointment of judges in the district courts. The procedure for appointment of judges in the district courts is either carried out by the High Courts or by the State Public Service Commissions. The process of Indian courts includes 2 tests. One is preliminary test, which is normally an objective test, and then main test, which is a subjective test. After these exams are qualified, a person is called for interview, and once the person clears the interview, the person is appointed as judge in the district courts. So, today we covered the topic of appointment of judges. In our next lectures, we will be discussing more about judicial system and various laws in the country. Till then, keep learning, keep growing. See you next time.